Liar. Everywhere. On netrootsradio.com. David Waldman. Kagro. In the morning. Now, here's David Waldman.
Hey, good morning, everybody. How you doing? It's Tuesday, March 19th, 2024. Time for another day with the nasal-sounding congestion issues. But it is another day. There's not much you can do about that. And until this thing knocks me entirely off the air, I guess we just continue to come in, check the news, vent a little bit. If we're lucky, get a chance to check in with Joan McCarter, figure out when the government next partially shuts down and why. That's what we have to do. And it is apparently the first day of spring. So this is now officially hay fever and not a cold. I don't know. I guess you could go and blame it on that. I don't think that's what the issue is. Although, if that is the case, then I would blame it on pear tree pollen or partridge pollen. I'm not certain which. I don't think I've ever seen a partridge in any of these things. But we have pear trees like you wouldn't believe. They're everywhere. Very few people have ever seen so many pear trees in a single place without seeing a partridge, actually. So, anyway, there's a lot going on. There's a lot of pollen we could be blaming this on, but I think it's just a cold. So we soldier on, and, we'll see if we can't squeak all the way through it. 3 segments, and then see how Joan's feeling. I don't know what the pollen count is like where she is, but at the very least, there's no performative impeachment wish casting, I don't think, going on in the House today that she has to be on hand to live blog. So we'll check in and see how that's going. Everybody's mind, I don't know, still for some reason they're all preoccupied with this guy who, the former president who's running for re-election and has secured the nomination of a major party in this country, calling for or insisting that there would be a bloodbath if he didn't win and something, but also he decided to add some anti-Semitic stuff to that last night and go on. Sebastian Gorka is still alive, as it turns out, and he still has a radio show. And Trump went on it to do some anti-Semitic mess and did the usual thing where if Jews don't support him, they're traitors to the country, is essentially what he got around to. But also, they're also traitors to Israel because if they support Democrats are very anti-Israel. And you, of course, have seen, lots of you who are very interested in Palestinian liberation have seen nothing but Democrats just piling up to be anti-Israel. That is so realistic. And I guess he decided he would, the position he's taking is he's bashing Chuck Schumer for having come out the other day with a very, what can we say about his speech? It was much needed and overdue. Not that I blame him for being overdue with it, but it's something we've all been kind of waiting for. And, of course, the idea of condemning Chuck Schumer as being anti-Israel is probably, if not humorous to most people, at least bordering on it. Anyway, it's insupportable, let's say. We could say that. So anyway, much condemnation and much deserved condemnation about that. I don't know how much time I really need to spend on it. It's certainly an issue of interest, but Donald Trump is a bigoted a-hole, and everybody kind of knows it. And it's not that we're going to look away or normalize it. We'll talk about it plenty. It's just, what do you say about a guy who comes out and says stuff like that? You cover it. You say he's a bigoted a-hole, that he should be nowhere near elected office, that you might reiterate, for instance, that continuing to milk the Trump train cash cow to the extent they're able to do so really ought to be regarded as elder abuse by his kids. He needs to be in some kind of protective atmosphere, not running for office, not endangering the country, not endangering himself, not endangering them, not squandering what might be left of the family fortune if it's not already gone. And the fact that they're continuing to exploit him for their own pecuniary gain is despicable and ought to be investigated as elder abuse. Let's arrest the kids. Why not? Okay, after a thorough investigation and all that. Yeah, you know how it goes. All right. Well, there's lots of other things to catch up on. Scott sent me something this morning that I just realized I never turned around and opened up on the desktop, but let's take a look. It is from Chris Geidner, I believe, law dork, and he's been following developments and arguments over the last day or so at the Supreme Court. They're still working. They're still hearing cases and ruining America. And let's see, yesterday's entry from Chris. Let's see if I can't. Well, let's see. Maybe I can move it over by pocketing it to a bigger screen where old people like me will be able to read it with less difficulty. This piece that Scott recommends comes, again, from Chris Geidner, who writes, "It isn't Justice Sam Alito's court, but Monday was about his far-right extremism." Now, Monday was yesterday, so I don't know what today is about, but yesterday it was about Sam Alito's far-right extremism. Let's see what they mean here. The Supreme Court's extreme decisions lead to more extremism from justices, lower courts, and lawyers. This is an interesting examination, and we're only at the subheader at this point. On Monday, Chris writes, "We saw how the far-right extremism of the U.S. Supreme Court's decisions in recent terms had created an environment where there is a constant rippling out of ever more efforts at moving that extremism even further right." This is Overton window examinations. At one point, around 5 p.m., it appeared that Justice Sam Alito had allowed his stay keeping Texas's criminal immigration law on hold to expire. Okay, whoops. All right, we got to get this pop-up out of the way here. That would have meant that SB4 would have gone into effect. Does everybody remember SB4? I remember the terminology, but let's see if we can't get a refresher here, because I'm sure he's not going to waste time on refresher at this point. But SB4 is Senate Bill 4, a bill that effectively bans sanctuary cities in the state of Texas. And this dates back to 2016. You get the idea. It probably struck you as somewhat dated as an issue, the sanctuary cities thing. That was something Trump used to rail about some years ago. And, but it sets up the basic dynamic also of Republicans insisting that in the name of American freedom, we cannot have these crazy top-down solutions where the government hands everybody some sort of mandate and everybody must simply obey. We want local control, all right? The local control says, down at the city level, we want to treat immigration this way. What? No, you can't do that. There will be a top-down solution, except the top will be from the state capital, passed down. It's one of many issues in which Republicans have decided they can govern that way. The federal government ought not to be able to tell the states what to do because states' rights, but states ought to be able to tell their subdivisions what to do because, I don't know, I guess also states' rights. But, it's not impossible to reconcile. It's just an interesting approach to things. And then, of course, should a sanctuary city or should a local municipality in Texas decide that they're going to be even tougher somehow on immigration than even Greg Abbott, that would be perfectly fine. I'm sure you understand. But okay, that's what SB4 is, dating back to 2016. But also, I guess they came back around. And there's another entry here from the Texas Tribune that says Texas lawmakers in 2023, last year, approved Senate Bill 4. The Wikipedia entry on it goes back. This might be something they try to do perennially. But it does list itself, SB 4, as having been enacted in 2017. So I don't know. Let me take a look at the Wikipedia entry here and see if it discusses the 2023 version of this. It doesn't, which is interesting. So maybe at this point, let me go back and open up this Texas Tribune article about it, just so we have some background here. Texas and the feds are at odds over the state's new immigration enforcement law. Here's what it would do. This is, I guess this one is current, written as of yesterday, and then we can jump back to Chris Geidner's analysis of things. The U.S. Supreme Court on Monday extended an order that blocks Texas from enforcing that law. So that's right. Chris has us in the right spot here. Just the opening paragraph of this piece, though. Texas lawmakers in 2023 approved Senate Bill 4, which seeks to allow Texas police to arrest people for illegally crossing the Mexico border. Okay, so that does make some sense. They, of course, 2023 would be a new legislative session as compared to 2016-17. It may just be the case that, any number of things could be happening. Either Republicans in the Texas legislature could have been capitalizing on what publicity they had for the first time around for SB 4 and have decided to use the SB 4 designation for subsequent anti-immigration measures. Or there, of course, could be the other phenomenon going, either of two, we'll say, phenomenons going on. One, they might sometimes reserve, as they do in the United States Congress, the first couple of single-digit bills for marquee legislation of the majority party. And for the majority party Republicans in Texas, marquee legislation means beating up on immigrants. They could be reserving just SB 4 itself, or it could be that basically 99% of all Republican legislation being brought forth in the Texas state legislature is anti-immigration legislation. And just by pure happenstance, SB 4 is one of the 99 billion anti-immigration bills that they have to consider. So at any rate, the 2016-17 version of SB 4 was about eliminating sanctuary cities in Texas. The current 2023 SB 4 allows Texas police to arrest people for illegally crossing the Mexico border, a federal authority. That's the issue there. It was expected to go into effect in early March, which is, now, although a little earlier than now, but faces legal challenges from the U.S. Justice Department and immigration advocacy organizations, and the Constitution, of course. The U.S. Supreme Court has blocked the law from going into effect, and federal court challenges remain. So that's where we are. Chris Geidner explaining now that at one point around 5 p.m. yesterday, it appeared that Justice Sam Alito had allowed his stay keeping Texas's criminal immigration law on hold, allowed his stay that kept it on hold to expire. That would have meant that SB 4 would have gone into effect. It would have done so, as I covered here previously, there's a link to one of his earlier articles, on the basis of an unreasoned order from the U.S. Court of Appeals from the Fifth Circuit, covering Texas, staying a 114-page district court ruling that led to a preliminary injunction against enforcement of the law. Does everybody get that? I'm not certain I remember where the beginning of this sentence started here, but an unreasoned order from the Fifth Circuit that would stay a district court ruling that led to a preliminary injunction against the enforcement of the law. Okay, so that's what the Fifth Circuit was, of course, in favor of allowing this law to go into effect. The district court, not so much. And then the U.S. Supreme Court hasn't treated it yet, but Sam Alito had issued a stay, since he's in charge of the Fifth Circuit, at least a temporary stay, and then it looked like he was going to allow his stay to expire, allowing the Fifth Circuit Court's decision to take effect, which would have put the law into effect. I gotcha. Okay. So it also would have meant that Alito did so in the face of the federal government's argument that allowing Texas's law to go into effect would ignore what? The 150-year history of rules surrounding immigration enforcement. You know about that. And 150 years of enforcement, certainly, but even longer tradition of recognizing this as a exclusively federal issue. Only the federal government gets to determine immigration policy. It's just an unfortunate political notation that they are crossing into territory that happens to have organized itself around a particular state government. But the issue is that they're crossing into the United States, not that they're entering Texas or California or Arizona or New Mexico or what have you. That's always been the case. All right. So back to what Chris was saying. When Alito's self-imposed 5 p.m. deadline passed, reporters, yours truly included, reported that the law had gone into effect. I guess there was a stay out there that said, all right, well, this thing expires at 5 p.m. Unless you hear from me otherwise, you can assume that the stay has expired at the given time. The time came around. Chris Geidner, among others, assumed, all right, that's Alito letting his stay expire. This is, as we recalled, what happened with Texas's vigilante enforcement abortion law, SB 8, a few years ago. They really love that and the anti-immigration stuff, so they make those the single-digit bills, I guess. At 5:04 p.m., however, reporters received word that Alito has extended his stay, pending further order of the undersigned, Alito, or of the court. So SB 4 remains on hold. It's 4 minutes late, but they can do that over at the court. Oh, yeah, by the way, it expired at 5, and at 5:04, did I reimpose it? No, I simply declared that 5 o'clock didn't matter anymore. Just, pointing that out along the way. So yes, SB 4 remains on hold. As of now, I don't know what happened. I don't know if the stay lapsed for a few minutes, as is what appears to have happened, or if there was a delay informing the press and public of an order that came from Alito just before 5 p.m. He's obsessed with the same issue. Okay. Very good. That means, by the way, good eye Scott for not just seeing an issue of importance and bringing it to our attention, but bringing us a treatment of the issue that is totally in keeping with our approach to how things should go, how analysis should be done on this show. Well, no surprise. Chris Geidner's pretty good about this. Anyway, despite the significant confusion caused by the timing, no one was saying on Monday night when Alito's order was issued or when the parties were informed. I mean, you see why, that it's kind of embarrassing, I guess. But given that the court can say, for all intents and purposes, we issued this at 5:04. Yeah, well, what happened between 5 o'clock and 5:04? Nothing. I mean, look, Texas wasn't going to, deport anyone between 5 o'clock and 5:04. Probably. I mean, what if they did? That'd be interesting, too, because that would make a hell of a case. But they could just easily say, we meant to do this at 4:59. The printer didn't work, right? It was warming up. It was out of cyan, and we had to add ink, even though it was a black and white thing. You know how it is with these printers. And look, the thing came out at 5:04. We know what time it is. It's 5:04. Does this extend the stay? Yes. Does it mean that there was a lapse of 4 minutes? No. Doesn't that defy logic? Yes. What are you going to do about that? Nothing. Why aren't you going to do anything about it? Because we're the Supreme Court. Who are you going to appeal to? You can't, there's no court you can go to and say, there's a 4 minute gap, Your Honors. I suggest that this is all there is. So, we might be obsessing over nothing here. But it is interesting, for a court that's supposed to cross all the T's and dot all the I's. I guess they don't care. And maybe it's fine. I really don't know. Let's see. As of now, as Chris said, I don't know what happened. We don't know if this stay lapsed for a few minutes. We don't know if there was a delay in informing the press of an order that came just before 5 p.m. Despite the significant confusion caused by the timing, no one was saying on Monday night when Alito's order was issued or when the parties were informed. Neither Texas Solicitor General Aaron Nielsen nor the Supreme Court's Public Information Office responded to requests seeking information about when the order was received or entered, respectively. A spokesperson in the U.S. Justice Department's Office of Public Affairs emailed that they were not able to confirm when DOJ was informed of Alito's order. Now, it is possible that there were behind-the-scenes goings-on at the Supreme Court that led to this strangeness. The printer. I mean, I blame it on the printer. Maybe Alito didn't want to extend the stay, but Chief Justice John Roberts and others convinced him to do so. Parenthetically, he notes, as I posited at dinner, perhaps he was told that a majority of the full court would do it if he wouldn't. Who knows? Not me. But no one is saying what happened. And despite the fact that for 4 minutes it appeared that Alito had fundamentally and single-handedly changed the way immigration law worked in America, that was not, however, the only sign of a legal system where far-right extremism is encouraged on Monday. That is interesting, and it may turn out that, this one doesn't fit the pattern, but it is interesting that for 4 minutes it looked like one justice alone was using the system in a way that would have upended 150 years of immigration law enforcement in this country. Why only 150 years? Okay, first 100 years or so of immigration was just, in an example of if it was good enough for the founders, it's good enough for us. No, open borders, more or less, good enough for the founders, but a huge problem for the yeehaws that have taken over in their name. Anyway, the justices heard oral arguments earlier yesterday in a pair of cases raising the question of when government actions urging private companies to take actions against third parties goes too far for the purposes of the First Amendment. Essentially, almost everyone ultimately agreed the questions come down to coercion. What are we talking about? Let's continue on, and I think it becomes clear. You have to demonstrate some coercive threat, some invocation of regulatory adverse action. The ACLU's legal director, David Cole, said in the second case of the day, where the ACLU is representing the National Rifle Association in its challenge to New York's effort to get insurers to stop doing business with the NRA. Even in NRA versus VULO, it appears to be quite a sign that the ACLU believes the best way to get a good ruling for advocacy groups on this First Amendment question is by having the NRA as a plaintiff. The government is, in most situations, going to be violating the First Amendment if it coerces a company into doing something that the government couldn't do itself because of First Amendment limits. In the first case, Murphy versus Missouri, that first case is over the Biden administration's efforts to get social media companies, this is the part I heard most about, to get social media companies to take action preventing COVID and election disinformation. I think we're all familiar with that. It might have had a similar feel to the second case, were it not for a combination of three things. The questionable presentation of facts by the plaintiff in courts below. That's becoming a bigger and bigger problem. I think he's going to be addressing that. A vigorous dispute over standing. Oh my. Armando is now going to kick the door down and tell us what a joke standing doctrine is. And the extreme legal position taken by the states and private parties challenging the government. All three of these extreme positions were more or less encouraged by the Fifth Circuit, since it got the case last summer. On Monday, though, Alito was the main voice defending the challengers from the bench, even pushing back against questions from his fellow conservative justices. Alito had a weird thing about trying to bring the press into the case, but in doing so, he instead showed a complete lack of understanding of how journalists and government officials and employees interact, something that both Justices Brett Kavanaugh and Elena Kagan had to point out. All right, what's happening here? Let's give a quick fill-in before we hit our break. The facts. I'd like to have the facts. Here they are. After disputes over the facts in multiple recent cases have led to lingering questions about the court's rulings, Justice Sonia Sotomayor was not going to let these questions go by in the Murthy case. Addressing Louisiana Solicitor General Ben, Aguinaga, I think that might be right even, representing the challengers, Sotomayor bluntly challenged him, connected the factual questions to the standing question. I have such a problem with your brief, counselor, she said. You omit information that changes the context of some of your claims. That'll get you in trouble, usually. You attribute things to people who it didn't happen to. At least in one of the defendants, it was her brother that something had happened to, not her. I don't know what to make of all this. I'm not sure how we get to prove direct injury in any way. I mean, sometimes not all of this is obvious in the way it is to legally trained folks, but non-lawyers probably get some sense of understanding of the constitutional requirement that Article 3 courts address only actual controversies, no hypotheticals. It's not something that the courts are supposed to deal with ahead of time. If you can prove an actual problem with actual injuries, that's where standing comes from, especially if there is actually a remedy that they can offer you for it. And that's actually a requirement in the standing test. But in other words, it's an increasingly frequent thing that how shall we say, conservative causes find their way to the courts in the form of these cases where the thing complained of hasn't actually happened, and yet they come up with some weird theory about why it is that the court would have jurisdiction to address it. A cake maker who fears being asked by a gay couple to make a cake these days can actually get all the way to the Supreme Court on that fear.
Hi, I'm Scott Anderson, the guy that writes the daily summary for this show, Kagro in the Morning. Thank you to everyone that supports this show. Many of you send donations through PayPal, Patreon, Square Cash, Radio Public, and so on. Some of you write your own essays and send them in, or read articles with your own commentary. We appreciate it. Now, some of you are listening to this and thinking, I'd like to help, but isn't there something I could do that wouldn't require money or effort? Why, yes, there is. You can just like us. On Daily Coast, they call it the recommend button. YouTube has a thumbs up. There are hearts and likes and love buttons. Tap our love button. Tap our love button every day. Share our shows and summaries on Facebook and Twitter, YouTube and iTunes, Stitcher and Amazon. Most of these places allow you to write a review, so a sentence or two would be great. Recommend us to social media, or tell your friends to listen to the show. You aren't just helping us, you're helping them find their new favorite thing to listen to. You could change the world. So thank you in advance from me and everybody else in the world.
All right, welcome back now to the Kagro in the Morning Show here on Net Roots Radio. Woo! All right, let's read through the rest of this. By the way, well, I won't interrupt at this point, but then I'll jump to, I'll say now what the next story. No, I won't. How's that? I'll keep you in suspense. What will my next story be? You never know what could develop between now and then. So keeping my eyes open and continuing though with what Chris Geidner was telling us about what I thought he was going to go into was a recitation of the facts of the case, but in fact it is a recitation of the problems that the court has had of late with even deciding what the facts of the cases before them are and how much time they will spend discussing them. Ordinarily, the Supreme Court, chiefly an appellate court, though, they have the right to do anything that they want, but, the court structure in this country, it's the district court, the frontline trial court, that is the trier of fact, as they say, and the finder of fact, in most cases, the jury. You can have a bench trial, of course, in federal court, but the facts of the case are supposed to sort of be established for good and all by the trial court. The appellate courts, when they agree to entertain an appeal, and I think also Trump is getting us out of the habit of discussing the fact of appeals typically, very frequently being denied, that you need to have a basis upon which to appeal, a legitimate grievance with the way the trial court handled the trial, that some material fact or finding of the court is likely to change upon appellate review. Not just, I didn't like the outcome and I have money, even though that's a lie too, to pay my lawyers, which I'm also not doing. But it's not a matter of I have the resources and so I'd like this looked at again. It's I have the resources. Yes, that's true, but that's a matter as between you and your attorneys. And I would like this issue reviewed. I think that the court incorrectly decided the question of whether or not certain evidence ought to have been admitted. I think there was a mistake of law. They just merely misunderstood the law as it's supposed to be applied. Now, it doesn't take a great deal, and sometimes it hangs by a thread, but you have to convince an appellate court that there's something for them to reverse about the way the law was applied, not about whether or not you're actually guilty, not whether or not you actually did or didn't do this thing or should or shouldn't be, there should or shouldn't be held liable is something you can review. But the facts of the case are supposed to essentially be established and then essentially frozen in place. Now, there's doctrine upon which the Supreme Court can rely to have a de novo review, as they say, of the facts, to do it all over again, because who's going to tell them they can't? You can't appeal from that. But if the appellate court wanted to have a de novo review of the facts, that's something that could provide a basis to appeal to the Supreme Court and say they really shouldn't have been able to do that. They're more limited in all of this. But that's regular doctrine. That's the way things are normally supposed to work. What's interesting here is that sometimes you, particularly when you're judge shopping, even worse than jurisdiction shopping, but judge shopping, if you get yourself one of the lunatic Trump judges or one of the people who are known for advancing conservative causes through the courts, you get a Matt, what's his name? Kaczmarek. Anyway, you get one of these guys, and they're willing to look ridiculous, locking down a factual record that doesn't make any sense to anybody but conspiracy-addled Republican conservative wackadoodles, and then pass it on to the Fifth Circuit, which is also full of Republican wackadoodles and unlikely to disturb anything anyway. But even if they wanted to, they shouldn't be allowed to pry open the record and change the facts. And then it gets passed on from there to the Supreme Court. And you end up having people like Alito, and going back to his day, Scalia. I'm just thinking about the cases, like the Affordable Care Act cases, where you had Supreme Court justices like Scalia sitting on the bench during oral arguments talking about the broccoli mandate or the Cornhusker kickback, things that were essentially talk radio fodder that weren't in the bill and weren't in the case, but they entertain as though they were, even though it's not actually part of the fact pattern of the case. They just convince themselves that it is. So it's of interest here. That's why the facts is an issue here in Geithner's article. After disputes over the facts in multiple recent cases, did anybody even ask you to make a cake? Did anybody even ask you to constrain the speech in question? Did anybody even ask you whether or not you would execute this subpoena for this information? In many cases, the answer is no, which in years past, courts would have used to say, this is not a controversy we can address. You'll have to wait until there's a harm here and then come back. So after disputes over the facts in multiple recent cases have led to lingering questions about the court's rulings, Justice Sonia Sotomayor was not going to let these questions go by in the Murphy case, and she put it to the Louisiana Solicitor General with the quoted statement that she has problems with the brief, that you omit information that changes the context of some of your claims, you attribute things to people who didn't happen to. This is an issue, and the Supreme Court has not always been good of late I mean, they're sort of, I guess, relying on the tradition of, well, the facts are the facts. They've been established below, but they're increasingly finding the facts were established by partisans and they were untrue. And the Supreme Court needs to retain its ability and exercise its ability to open up the record and say, I can tell you that this is a frame-up job. We've seen this, watched it from the district court. We've read the record. There's no reason that this should have been accepted as part of the fact pattern of this case, but it was, and I call the whole thing into question. So, to this, Aguinaga began by responding with an apology and a screen grab of the transcript of the court proceedings from Monday. So, Justice Sotomayor, he says, let me start by apologizing if any aspect of our brief was not as forthcoming as it should have been. I will take full responsibility for that. I apologize for that, Justice Sotomayor. He's doing his best, damage control. Although he didn't directly take back or change anything, it was an astounding moment in an argument that could have gone off in a very different direction. One that we later saw Alito had wished it had gone. During the seriatim questioning, I don't even know if I recall the use of that term, but seriatim meaning taking one subject after another in regular order or point by point. Okay, it's just a good SAT word for the zero of you who are going to take the SAT again. During the seriatim questioning, when the justices, that is, go one by one asking questions at the end of each lawyer's argument, Alito attempted to rehabilitate the challenger's position, asking his former clerk, that's, Aguinaga, his former clerk, a friendly question, trying to get things back on what he apparently saw as the right track. So Justice Alito puts the question this way, and it's his prerogative to do so. It's cheating, but you can do it this way. Well, Mr. Aguinaga, I think some of your most recent colloquy with my colleagues has gotten off into questions that I didn't take it from your brief that tugging at the collar, that you think we actually need to decide in this case. Well, it wasn't happening. I guess it didn't work out for him. The next section here, standing, also the running joke of standing doctrine. When Kagan followed Alito, she pushed even further on the standing questions, asking how the challengers can say it's the government rather than Facebook leading to these decisions, prompting Aguinaga to respond that you could say the same thing about how do you know it's Facebook and not the government. At which point, Kagan agreed, telling him he was exactly right, which, bluntly, is something you almost never want to hear Kagan tell you at oral argument. It generally means it's over. I guess if you've stepped into the trap. Exactly right. I guess if you're going to use standard ideas about traceability and redressability, Kagan said, of 2 of the 3 requirements for standing, I guess what I'm suggesting is I don't see a single item in your briefs that would satisfy our normal tests. Uh-oh. And yet there they were. The law, the next issue. Does anybody care about that one? Again, on the merits. While most of the advocates and justices on Monday were focusing on coercion and the 1963 Bantam Books versus Sullivan case, addressing when government action directed at a speech intermediary amounts to informal censorship, it was telling that Aguinaga was still pushing farther right. The Fifth Circuit's ruling, which sided with the challengers on several key issues, discussed its test as addressing coercion or significant encouragement, and relied upon the 1982 Blum versus Yaretsky case that set forth a test for finding state action. That was, most of the discussion on Monday suggested, the test that the majority of the court wasn't likely interested in using, but for Aguinaga it wasn't even far enough, as this stunning exchange with Justice Amy Coney Barrett made clear. When Aguinaga said that one potential mechanism is coercion, another one is encouragement, Barrett asked, just plain vanilla encouragement, or does it have to be some kind of like significant encouragement? Because encouragement would sweep in an awful lot. Aguinyaga says, well, I think that's right, Your Honor, and so let me give you two answers to that. The top line answer is, I'm a First Amendment purist. Oh, boy. And so I would say even mild encouragement. But we don't need that to win this case because we are so far afield from whatever that threshold is. So if you want to say substantial encouragement, like the Fifth Circuit said, and like Blum said, absolutely, that's a standard that works. If you want precedent, sure, I guess we could do that. Aguinyaga essentially told Barrett after giving his top line answer of what it feels like it should be. Why argue precedent when you could argue vibes? Because that's exactly what the 6-3 majority decisions encourage. Okay, very interesting. Just it's a little bit in depth, and we haven't really gotten all the way there in explaining what the twists and turns of the issues at hand in these cases are. It's mostly valuable for reminding everybody about the way facts in these cases and standing are supposed to be established well before they reach the Supreme Court, but the Supreme Court loves to bend the rules in order to get the case that it thinks would be the most convincing. They love to have, this is something advocates at the repeat players as advocates at the Supreme Court have done all along for many years, looking for the most sympathetic possible client. I don't know, just to give an example in the context of abortion cases, they'll want somebody, they know that there's a conservative bias against women having autonomy over their own bodies, essentially. And so it won't do in this kind of advocacy, they figure, to come with a normal woman who simply says it is, it's a problem for her life and career and even marriage to carry a baby to term, and so therefore just simply does not want to and is seeking an abortion. It's more clarifying for these proceedings to come with somebody who has become pregnant against their will in one way or another. I guess there's really no way of putting it beyond saying that's rape. You become pregnant against your will. Well, there's certainly unplanned pregnancies with consensual sex, but an unplanned pregnancy. But yeah, they want the most sympathetic possible plaintiff. They're going to say somebody who's been raped. It may be. Then they'll throw in, essentially, you want to cut off all avenues of escape. You need to present the court with someone who's been raped, someone who's underage and has been raped, and is likely incapable of taking care of the child. Perhaps their life is in danger just from carrying the child. So, a young teenager or even younger who's become pregnant from rape. And just to make it even worse, we'll throw in that it's incestuous rape. And, plus on top of that, she's, I don't know what else, right? Has been in the choir at her church for a million years. Oh my God, she's pious as well. And it's, anything they can do to squarely make it only about this issue, or so that there's no avenues of escape, so no one can slut shame the plaintiff into believing that she should carry the child to term, or anti-abortion advocates could point at and say she's wrong about this. They still find a way anyway, obviously, but that's essentially what all of this is about, framing the issues of the case in the most crystalline possible way. And it's become conservative practice of late to simply fib their way into that. This is a cake baker who's been asked, is being forced to bake a cake for a gay couple, even though something religion, yada, yada. And like, well, no, they haven't asked. Who is this person who's asking for the cake then? I can't tell you, or there wasn't such a person. I'm just worried that there might be. Let me ask you this. How long have you been in the baking business? Now that you ask, I'm not actually a baker, but I was thinking of going into the baking business. Really? And so you're upset about Oklahoma's, well, I'm just picking. They probably were involved in the case. Oklahoma's law that says you would have to bake the cake. Why did you decide to go into baking then in Oklahoma in particular? Given that as I look over the record here, it says here, you're a computer software engineer. You're merely thinking of going into baking, and you live in California. How is it that you had a hypothetical bakery in Oklahoma? Well, I might move there. Why? Are you kidding? Court's not supposed to address this sort of thing, but the Supreme Court has found itself in these situations. That's weird. You don't live in Oklahoma. You're not a baker, and no one asked you to make a cake, gay or otherwise. I know, but it could happen. To a software engineer, why not? I have flour in my house. All right. They'll consider the case. I don't know. Someone ought to be. Well, people have been writing about that. Chris, I'm sure, has discussed this in the past. That's the heart of what's going on in his examination, I think, if I have it correct here. But anyway, an important and interesting piece, and I'm glad Scott shared it with us. And it now brings me back to the point I wanted to share earlier, which I guess is a good follow-on from Chris's thing here. I want to know about the time breakdown here. It's not enough for you to tell me that it expired at 5 o'clock, and then at 5:04 they said, never mind, it didn't expire. How did that happen? But more technicalities here. Today, being March 19th, it is, in fact, we might as well just announce it now. It's Report to Prison Day for Peter Navarro. Yes, as it turns out, he too tried to appeal his order to report all the way up to the Supreme Court, and he kind of sort of got there. That is to say, this case should have stopped a long time below, a lot further down, but somehow the Supreme Court, they were able to, they didn't take his case, but they had to take notice of the case, which really they shouldn't have. NPR has this report on the issue. I just happened to grab that one and put it up, but then I'll give you today's update. This from yesterday, ex-Trump advisor Peter Navarro to go to prison after Supreme Court rejects his appeal. And really, why were they even involved? But the U.S. Supreme Court on Monday declined to save former Trump advisor Peter Navarro from serving his 4-month prison term. Navarro has been ordered to report to prison on Tuesday. The Supreme Court order came from Chief Justice John Roberts, who acted alone, though it is unlikely that there were any serious objections from other justices. In September, Navarro, who served as trade advisor in the Trump administration, was convicted of contempt of Congress for refusing to comply with a congressional subpoena for documents and testimony related to the January 6th attack on the Capitol. He was sentenced in January to 4 months in prison. He is the second former Trump insider to be convicted of contempt of Congress. Steve Bannon was earlier found guilty in 2022. So all of 2023 passed, plus some time on either end since that happened, and yet not in jail. But he was convicted on the same charges, sentenced to 4 months, just as he was. Bannon has appealed his conviction, and the the U.S. Court of Appeals for the D.C. Circuit heard arguments in November of 2023, but has still not issued a decision on the case. Anyway, back to Navarro. The Supreme Court's decision in the Navarro case on Monday could well speed a decision in the Bannon case. I guess it's possible that in all good faith, maybe, the panel on the D.C. Circuit was saying, well, I guess let's see what happens with Navarro. If the Supreme Court says F off, go to jail, then we'll say, all right, we had it right. Let's issue our decision already and get to it. Well, today is report to jail day. I haven't heard anything from the D.C. Circuit, but I haven't been looking either. But the nature of Chris Geidner's inquiry into, well, what happened with this 5 o'clock 5:04 thing made me say, Well, what time does Navarro go to prison? That is to say, it is 9:51. We're in the middle of our program. Things happen all the time in the middle of our program. Is Navarro in jail yet? Like, the jail's open. You could go there, before breakfast and report to prison. But I'm just sort of curious, like the mechanics of it. If the court says you need to report to prison on Tuesday, March 19th, I mean, my assumption is you say, is 11:59 p.m. okay? I mean, every minute I'm not in jail is, I guess, good. You may also look at it like, let's get this thing started already. I'm going to do my 4 months. I want it over with, and I want to be released in the morning, first thing in the morning, when my 4 months is up. And again, I don't know what obligation the prison system is under to do that. I doubt very much that it's a matter of, well, if you punch in at 7:59 a.m., you got to be out by 7:58 a.m. 4 months hence. The prison system may very well say, you're going out, but at 11:59 p.m. in 4 months from now. I don't know what kind of flexibility they have. I've not been inside, so I couldn't tell you. But it's of interest to me. So is he in prison yet? Can we announce that? No, I guess not. The latest that I was able to find on this is from The Guardian. Trump ally Peter Navarro to begin prison term after contempt conviction. It is published this morning, 5 a.m. Maybe a little early to do processing at the federal prison. I don't know. But as of 5 a.m., he wasn't in yet. I went looking for anything that would tell me what time he was supposed to report. And I imagine you work this stuff out ahead of time. And I don't know whether they give you a range. I don't know if they say you got to be here at noon and 12:15 rolls around, they start looking for you. Probably not. I'm just curious, Anyway, he's supposed to start his prison term. Navarro, of course, convicted for refusing to cooperate with the House January 6th committee, is, as it says here, to report to a Miami facility. He's going to go to jail in Miami for some reason. And they make a big deal out of this in a couple of articles. The jail is next door to a zoo, which is interesting. And also leads me to my upcoming New Line cinema production. I'm fully funded and in development. We Bought a Prison. It's the sequel to We Bought a Zoo. And it's about consolidating your properties and then eventually opening up a sex pervert dungeon to compete with Pervalago. I don't know if anybody's interested in developing this stuff. But if so, if there are any movie producers in the audience, I'm looking to make a gigantic windfall. Why don't you pay me a bunch of money and then you make the movie? And I think that's the way it works in Hollywood, essentially. I don't know. And then I go around saying I'm in development and I dine out on the money. I don't know how this stuff works. I don't know. It's my impression of how this stuff works in Hollywood. I gather I'm actually wrong about that. But if you would like to send a big chunk of money, Patreon.com/KagroX is a great way to do it. So is the Cash App. PayPal works. Personal check also okay. And if you've got one that big, I'll give you the home address and you can send it to me. All right. Well, at any rate, Peter Navarro, former trade advisor to Donald Trump. How did I get to this again? I don't know. Anyway, was on Tuesday set to become the first former White House official ever jailed for contempt of Congress. Okay. Interesting. And contempt of Congress has been of personal interest to me for quite some time. And the longtime listeners and people who read Congress Matters and Daily Kos for years before there even was a radio show will remember that contempt of Congress was a big issue for me in the George W. Bush administration because, of course, they were among the early Republican practitioners of this particular kind of interbranch gamesmanship and really played it to the max and were the first ones to reveal to me, anyway, I'm certain people had come to this conclusion earlier, that there really was a huge gray area in terms of how much could Congress leverage and coerce from out of the executive branch, given that it was the executive branch that was in charge of prosecuting the crime of contempt of Congress once Congress decided that it wanted to enforce that charge statutorily as opposed to using its inherent contempt powers. Sort of fallen out of fashion, inherent contempt. And actually, this brings me back to a story from a couple of days ago when we were reading. Who were we reading? Oh, yeah, right. It was the story of Ringwis and how he found very frequently that members of Congress often did not really know the rules of procedure as well as he did. And that's very understandable. I had to run into the same phenomenon. And in some cases, it has to do with the fact that, well, you know, does a member of Congress have as much time to study the history and development and nuance of the rules of procedure and the precedents as somebody who's a student somewhere and can spend hours on end effing off in Deschler's precedents to look this stuff up? And the plain answer is no, and with good reason. But that's good reason to have both, of course, members of Congress and people who do have that kind of time on their hand to figure that stuff out, and then they can confer and cooperate to apply the precedents properly. But very frequently you find that members of Congress instead say, I've been advised the opposite of what this person who is a self-appointed and self-educated, and well done at that, self-educated expert in these things, and I just don't care what they have to say. They're nobody, and I'm going to blow right past them. But in case you didn't think, or you thought perhaps this was unique to Ringwis, no, I had run into it as well. I gave a couple of examples, but one of those examples has to do with this, contempt of Congress. When we did some research of our own, when Brad Miller of North Carolina was in Congress, and finding that this was the case, that Congress's power to enforce its own subpoenas was in fact quite limited under the statutory contempt procedure, that inherent contempt was something that they would have to resort to in order to enforce the law. And we found that others who had been in Congress for quite some time and were considered procedural experts in their own right, like Henry Waxman, chair of, well, several committees over the years, but found himself at the chair of the Government Oversight Committee and had no idea that there even was such a thing as inherent contempt 20 plus years into his career. All right, welcome back now to the Kagro in the Morning Show here on Netroots Radio. Let's find our footing again here. We were talking about Peter Navarro and his need to report to prison today, and then find out what time he was supposed to report to prison. I still don't have an answer for that, but then we kind of got into rules of procedure and the reasons why it was important to delve into them, and we got sidetracked here. But it was all about contempt of Congress. But by the way, I don't have any explanation for why it's of interest or how it even came to be that there was a federal prison facility next door to a zoo. But for those who are interested in that angle of the story, I will finish the Guardian's work on that. This was the one published early this morning. We were still waiting, and they still didn't have a time for when they expected Navarro to report, but sentenced to 4 months in prison for refusing to cooperate with the House January 6th committee. The 74-year-old economist, and I think he should have seen earlier on that the economics of the issue were, look, they've got you dead to rights. You should just report and get this sentence over with already. But the 74-year-old economist appealed all the way to the U.S. Supreme Court, claiming he could not testify as his work with Trump on attempts to overturn the 2020 election was covered by executive privilege. It was not, but that was his claim. His appeals were unsuccessful, and he was due to report to a minimum security facility in Miami. On Monday, Sam Mangel, M-A-N-G-E-L, a prison consultant working with Navarro, told CNN the federal satellite camp was next to a zoo. Well, thank you very much, Mr. Consultant. Thanks for looking that up. Not only can you hear the lions, Mangel said, you can hear the lions roar every morning. That's that's, not really the follow-up I was looking for. First of all, I'm not really interested I guess I am interested in the lions. But not only can you hear the lions, you can hear them roar every morning. Well, that's how you hear a lion, by hearing them roar. And two, not only can you hear them, you can hear them frequently. You can hear them every morning. It's like not really revelatory. Not only can you hear them, but you will hear them multiple times. I fear you may have come to the end of your interesting information about the proximity of this prison to a zoo. But all right. The New York Times has described prison consultants, a good eye for the Guardian here, saying, yeah, people are going to want to know, what do you mean prison consultant? Well, the New York Times has told us what prison consultants are. They are fixers, teaching convicts how to reduce their sentence, how to get placed in a better facility, and make the most of their months behind bars. Right up until the end there, that's really your lawyer's job. How can you reduce your sentence? How can you get placed in a better facility? That I would look to a lawyer for, but not all lawyers know that, and they might very well hire prison consultants to help them. But then at some point, the prison consultant becomes of personal interest to the defendant themselves by teaching them how to make the most of their months behind bars. I gather there's also a little bit of, if you're threatened, here's what you should be doing. For Navarro, they might be able to say, you might want to join one of the Aryan gangs in there because they're very big Trump fans, and maybe they'll help you out. But I don't know how much there is of that going on in the minimum security facilities. But that was the idea, to get him into a cushier place where a 74-year-old rich guy wasn't going to end up getting stabbed all the time. Now, why Navarro has said, no prison can hold me and no prison shiv can injure me, I don't know. That's a huge lie. Made that up entirely. But if it were to circulate that were the case, well, someone might take the challenge. I don't know. I'm more interested in seeing Bannon's obvious threat to the prison community and challenge to their system that no one can contain his mighty fury. That should circulate rather than Navarro, but okay. Just testing out the system at this point. Navarro was nervous, Mangle said, adding anybody, regardless of the length of their sentence, is going into an unknown world. I would be nervous too. Peter Navarro is finally right to be nervous about going to prison. But what can I tell you? If you can't handle the, you could always resort to, if you can't do the time, don't do the crime. But if you can't handle the nervousness, remember you shouldn't engage in the perviousness. I guess possibly might work as if you with a little poetic license. Navarro is not the only former Trump advisor convicted in relation to investigations of attempted election subversion. Of course, there's Bannon, and as they point out, Trump himself faces 88 criminal charges, 14 related to election subversion, while struggling to pay multi-million-dollar civil penalties. Are we down from 91 to 88 now because of the dismissal of some of the charges? Was this criminal? Yeah, okay, not just federal criminal charges. So I guess that would encompass the latest happenings in Georgia. In a Trump White House riddled by infighting, Navarro was a particularly controversial presence, particularly during the COVID pandemic. After Trump lost the 2020 election to Joe Biden, Navarro boasted of his involvement in attempts to overturn that result, in part via a plan he called the Green Bay Sweep. That drew the attention of the January 6th committee, which investigated the attack on Congress by Trump supporters, but Navarro defied them. And at a sentencing in January, a judge told him, "You are not a victim. You are not the object of a political prosecution. You are the circumstances. These circumstances, rather, are of your own making." Also of Navarro's own making, memorably, were quotes in his academic work attributed to an economics expert called Ron Vera. That is an anagram of Navarro. Why, by the way, why isn't he being questioned the way Claudine Gay was about plagiarism or fakery? I am not certain. Anyway, still, By reporting to prison on Tuesday, Navarro was at least set to lay claim to a place in U.S. political history. One of his lawyers, Stanley Brand, told CNN Navarro's jailing was a historic moment that should stand as a warning to future White House aides who get subpoenaed by Congress. And I'm glad of that, and he's right about that. And like I said, it's been a long time coming, establishing that members of the executive branch can, in fact, be jailed for defying subpoenas from Congress, because it was highly questionable how that was going to come out for many years. I mentioned to you in recounting or remembering the Ringwis story that we were looking at about whether or not people really could be sent to prison for defying congressional subpoenas. You would think yes, as there is a statute that says that contempt of Congress is against the law. And for quote unquote normal people outside of the executive branch of government, for instance, it's been used. It's not common, but it's not unusual. And defying a congressional subpoena can land you in jail. Right? You say you defy their subpoena. The Congress makes a referral to the U.S. attorney, usually the U.S. attorney for the District of Columbia. That's where the crime took place, presumably. And you can find yourself on trial pretty quickly for contempt of Congress when Congress refers those complaints to the U.S. attorney. Now, the problem arises when it is a member of the executive branch who you have subpoenaed. And very frequently you do have to do that because you're, pursuing Congress's legitimate interests in investigating some, activity that should never have taken place, or not in the form in which it did take place, or whatever, or that you're holding on to information that Congress needs in order to make legitimate legislative decisions. And the executive branch says, well, we're co-equal branches here. You can't force me to do this. I have all sorts of prerogatives as a member of the executive branch, or I'm acting on orders of the president as a member of the executive branch. And the problem really arises when Congress says, we don't believe you. We disagree. We want to prosecute you for contempt of Congress. And the usual procedure is to ask the U.S. attorney for the District of Columbia to do it. But the U.S. attorney for the District of Columbia then reminds you, I too am a member of the executive branch. And especially when the executive branch is in the hands of a party opposite that of the Congress, which is making this referral for contempt charges, this raises issues. And it did in the George W. Bush days, when numerous executive branch officials likewise refused to answer questions or turn over documents to an investigating congressional body. And the statutory contempt regime didn't look like it was going to be robust enough to get to a prosecution. And digging around in the rules, as we did, as Ringwis has done in subsequent years, we found the inherent contempt procedure, which had fallen out of favor over the decades, but was still on the books, and still, I think, underlay the theory of the statutory contempt of Congress procedure. The reason that they felt comfortable adopting a statute and delegating contempt prosecution to the executive branches, usually they weren't actually seeking contempt against other members of the government, and particularly executive branch members. Usually it was outside the government that they sought to enforce it. And so there was no separation of powers issue for the executive branch on behalf of the legislative branch to prosecute non-governmental defendants for contempt of Congress. But when it's inside the government, or you're investigating the government and they're not complying, what do you do? And as Ringwis found in later years, we found that there were members who were supposed to be in a position to know about inherent contempt and just didn't. I was reminded of that recently and said, well, what was that one all about again? I went back to a April 2007 entry at Daily Kos that I wrote, which asked the question, does your delegation know what inherent contempt is? Of course, I had spent a couple of weeks at that point explaining to people what it was. And now I ask them, now that you know, does your member of Congress know? That's a serious question, I started off by saying, and it's not meant to impugn anyone's intelligence or integrity. The plain fact is that sometimes you'd be surprised what you know about that your representative or senators just don't. To be sure, they'll sometimes amaze you with their knowledge of legislative arcana, but the truth is that the schedule of a legislator is tight, and casual perusal of the blogs just isn't something that they often have time for, which means that if you've been reading here or elsewhere about the looming crisis in enforcement of the congressional subpoena power, and in case you haven't, I have a link that will bring you to that discussion, and have thereby gained an understanding of inherent contempt process, you may actually know considerably more about it than your representative in Congress. This same is true of much of what passes for common knowledge among blog readers, but we'll let that stuff be someone else's problem for the time being. I told people back in 2007. For now, I'd like to pass on a suggestion that I got from a fellow Cossack who may or may not want to be named, and so we didn't really do it, at the recent D.C. Yearly Kos fundraiser. Having struck up conversation with one of the lawmakers in attendance, this Cossack was surprised to find that the legislator he was talking with had not yet heard the story of Regent University's role in the scandals unfolding at the Department of Justice, the politicization of the U.S. attorneys, right? We talked about it afterwards and generally agreed that as knowledgeable and talented as our congresspeople were, we couldn't expect them to know everything that we were talking about. More than that, we generally agreed that it was incumbent upon us to see that the things that were really weighing on our minds didn't slip through the cracks because we thought our congresspeople already knew, right? That's very frequently the assumption. Well, clearly, don't you think they know that? They must have decided that wasn't going to work for some reason or another. Did they? And it seems that inherent contempt might just be one of those kinds of issues. There have got to be more members who know about the process that we just haven't heard from yet. But so far, the only member of Congress I know who's been thinking about anything other than we'll take them to court when the Bush administration defies congressional subpoenas is then Representative Brad Miller of North Carolina. He had actually done the right kind of research to find out, what can I do if this is going to be a problem? As chairman of the Investigations and Oversight Subcommittee of the Science and Technology panel at the time, he had run into administration intransigence that's just as brazen and stunning as any of the high-profile situations we, at the time, were witnessing at the Judiciary and Government Oversight Committees, but without the sexiness, of involving the A-list cabinet members. Miller has been working quietly and behind the scenes to make his colleagues aware of his read on the situation, but it's an uphill battle. Everyone's busy, everyone's freaking out, but not everyone is convinced, as both of us are, that the courts are not likely to clarify the situation for us, at least not in time to actually do anything about it. Right? So just without having to go forward any longer with reading this piece necessarily, in 2007, we were still trying to convince people that it was possible to put executive branch members in jail if they wouldn't comply with congressional subpoenas, right? And to that date, no one had ever gone all the way to forcing the courts to adjudicate it, all the way to, all right, you have to go to jail. That's why Stanley Brand is saying in this other piece here that this is historic. This is the first time that a member of a presidential administration has actually been sent to jail for defying a congressional subpoena. It takes a very special set of circumstances, politically speaking even, in order to get the very basic fact that subpoenas are supposed to mean something and carry a penalty if you defy them, to get courts to actually say, all right, on this date, you will finally go to jail. And this day is it. March 19th, 2024, we finally see an executive branch member being sent to prison that day, reporting to prison on something that we have been puzzling and fighting and positioning and pondering since the early 2000s. This article from 2007 saying, honestly, you can send people to prison for this. And remember also, this was also the days of, yeah, that's not how this stuff works. Well, it's how it's supposed to work, but it never has, because instead of demanding that the courts actually address the question of, well, can you force me to go to prison? Most people just said, let's not get to that. Let's come to some other agreement. And for years, there was no prosecution of contempt of Congress for defying these subpoenas because members of the executive branch were encouraged very, very, very strongly by the courts and others. Find a solution. Find some way that you can come to some partial disclosure to the committee such that they don't insist on prosecuting you for contempt. And when that didn't work, it was about reminding members of Congress, do you know that you are authorized to put people in jail yourself on your own authority, and that there used to be a prison cell in the congressional compound, the congressional complex, where you could put them? There was some dispute about where it was and whether it really existed in the place that people thought it was. But yes, it's true. Congress can imprison people on its own volition. They just haven't for a really, really long time. And once again, it was, look, we dug it up and it's true. And the reporters and members of Congress who didn't either do the research or didn't want to admit that they hadn't done the research or were uncomfortable with acknowledging this power, because then it would mean that they would either have to do it or not do it and explain to their constituents, I just didn't wanna, spent an awful lot of time and energy saying, no, that's not the way it works. You're wrong about this. You're a crazy blogger. No one knows where you got this. And it was from, look, it's your own precedents. Anyway, Ringwist knows what we're talking about. I can see you in the back there, even though you're not listening to the show, saying, yes, that's exactly what happened. Okay. Time now to jump to, let's say, another topic. Although I want to keep an eye out there to see whether anybody can tell us whether Navarro has showed up at prison in the last couple of minutes, to see if that's of interest to anybody out there. Keep an eye on that. Let us know if you hear about Navarro showing up. All right, a few more minutes before our third break, at which point we'll welcome Joan McCarter over to the show to talk about whether or not the entire government, or partially, will shut down, and which parts and why. And you can imagine what the reasons are. Whatever the outrage of the day happens to be, that's what they'll use to shut down the government. And guess what? It's typically going to revolve around immigration. Again, yeah, I know, it's hard to believe. But anyway, we'll get the nitty-gritty details of all of that. Let's see, other things that might be of interest that we can shoehorn in here before our break. Well, there might be one or two. This is news from Michigan that is always of interest. A great case study Michigan makes for what's going on in our federal and state systems. But the AP reports this piece that might become important, or might just be something that falls by the wayside in the end. Pro-Trump Michigan attorney arrested after hearing in D.C. over leaking Dominion voting systems documents. What's happening here? Nicholas Riccardi and Joey Capoletti get together on this one for a little, I guess, Italian-American fest. An attorney facing criminal charges for illegally accessing Michigan voting machines. Remember that this happened? After the 2020 election, was arrested on Monday after a hearing in a separate case in federal court in Washington, D.C. How do you like that? Stefanie Lambert was arrested by U.S. Marshals after a hearing over possible sanctions against her for disseminating confidential emails from Dominion voting systems. The target, of course, of conspiracy theories over former President Donald Trump's 2020 election loss. Lambert obtained the Dominion emails by representing Patrick Byrne, a prominent funder of election conspiracy theorists who is being sued by Dominion for defamation. In a statement, the Marshal's office said Lambert was arrested on local charges. A Michigan judge earlier this month issued a bench warrant for Lambert after she missed a hearing in her case in which she's charged with 4 felonies for accessing voting machines in her search for evidence, which didn't exist, of a conspiracy theory against Trump. Lambert had earlier unsuccessfully sued to overturn Trump's loss in Michigan. So it's Michigan charges she's being arrested on, even though she was in D.C. or supposed to be in D.C. on federal, to answer for some federal charges as well. Earlier Monday, Lambert had acknowledged passing on the records from Dominion voting systems to, quote, law enforcement, and that's in scare quotes. Why? She then attached an affidavit that included some of the leaked emails and was signed by Dar Leaf. That's supposed to be the law enforcement. Dar Leaf, a county sheriff in northern Michigan who has investigated false claims of widespread election fraud from the 2020 election. That attached to a filing in her own case in Michigan. So I guess that's the law enforcement that she was supposedly passing this on to, but Dar Leaf is a wackadoodle constitutional sheriff and involved in conspiracy theory in his own right. And I don't know whether he's the law enforcement person with jurisdiction over the area in which she was facing charges or not, but she clearly sent this information to Dar Leaf in the hopes that he would carry it forward and vindicate her with his own investigation. It wasn't a matter of keeping local law enforcement deprived of your activities, and so therefore you couldn't exactly be said to be surreptitiously breaking the law. But it doesn't really matter whether it's surreptitious or not. If you're breaking the law, notifying law enforcement doesn't mean you get to do it. It means they should arrest you for doing it. That's all. Anyway, the rest of the documents were posted to an account under Leaf's name on Twitter. How do you like that? So that's what he did with the confidential information. Leaf did not respond to a request for comment. Lambert's attorney, she's an attorney, but she has an attorney. Make attorneys get attorneys. That's MAGA for you. Daniel Hartman did not immediately respond to a request for comment. Byrne wrote in a text that he did not know if Lambert had been arrested, but if she was, I respect her even more, and she can raise her rate to me. I respect my lawyer even more for getting arrested. Lambert contended the Dominion documents obtained under discovery were evidence of, quote, crimes and needed to be disclosed. But that's not the way it works. Byrne wrote on Twitter that Lambert signed an NDA, but she found evidence of ongoing crime and reported it to law enforcement. Just, a particular person in law enforcement who happened to be a crackpot conspiracy theorist. If she found a severed head in a discovery box, she'd have a duty to report it to law enforcement too. Okay, that's Byrne's reasoning, but that's why you needed an attorney. You're not one. Dominion on Friday filed a motion demanding Lambert be removed from the Byrne case for violating a protective order that U.S. District Court Judge Mohila? How do you say that? Moxila? I don't think I've run into that name before. Mohila, probably. Although maybe it's not Spanish. Moxila Upadhyaya. I'm hoping I got close to the pronunciation. We have a very diverse judiciary in this country, and it's a good thing, but it's making me embarrassed that I can't pronounce their names. But, well, that's the least of my problems. I'd rather have them as judges and embarrass myself than not have them, of course. Well, this judge had placed a protective order on this discovery material. And basically Lambert said, well, to hell with that. I think America needs to know. Well, you go to jail when you do things like that. It said Lambert's disclosure had triggered a new round of threats toward the company, Dominion was claiming, and it's probably right, which has been at the center of elaborate conspiracy theories about Trump's loss. These actions should shock the conscience, Dominion wrote in its motion seeking to disqualify Lambert. Maybe being a little bit dramatic about that. That's dramatic music territory, but we got to have the slate clear for our break music instead. So we'll just say dun 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 and do that above the music. Why do they say, why is that so surprising, or why is that a reach? I don't know. Shock the conscience. That's actually, like a term of art inside legal circles. What sort of activity should lead to punishment in the judiciary system, or disbarment, or indicates that certain actions are above and beyond what should be allowable? Shocking the conscience. So they invoke that.
Hi everybody, it's me, David Waldman. Yes, the same guy who interrupts you all the time. Interrupting you one more time, just to tell you again, another reminder that your contributions are what keep this show on the air, and patreon.com, patreon.com, is still among the easiest ways to make the sustaining subscription donations that keep us afloat. Are you ready for the pep talk about how our Patreon campaign is still going strong and growing? Well, too bad. Yeah, the plain fact is we actually are headed in the wrong direction, and whereas we once had about 175 monthly patrons, we're now actually down below 150. Time to recruit some more. Not exactly the kind of news I wanted to share, but there it is. For those of you in a position to support the show, patreon.com does make it easy to make those secure recurring monthly contributions to do so. Patreon.com/KagroX gets you straight to our donation page. We've been through a lot together. The worst of the pandemic, we hope. The worst of the insurrection, we hope. So go ahead and treat yourself. You don't need an excuse. Give yourself the gift of a little something you enjoy in life. Support the show. And of course, if you happen to prefer using PayPal or even the Square Cash app, we're up and running on those options too. So thanks again, everyone, for all your support. We couldn't, or at least shouldn't, do it without you. Hope you'll be on board soon too. Thanks for all your support.
But they're going to probably need another CR for the weekend.
Okay. Well, welcome back, everybody, to the Kagro in the Morning Show here on Netroots Radio. Joan McCarter is with us to help carry me through the last half hour. But it being Tuesday, it's time to discuss what jeopardy there might be of partial government shutdown, etc., which departments might shut down if they weren't to reach a deal. But it's the habit lately for them to reach a deal. They go through periods in which Republicans forget how bad it is for them, how bad it looks for them politically and electorally to shut down the government. Also, everybody is now in the habit of saying, oh, there's a government shutdown, Republicans are doing it. It's nice that everybody knows where to lay the blame, even when the newspapers won't put it in the headlines. Everybody just sort of inherently knows. So, as a result, they've been less likely to allow that to happen at the behest of the craziest of their most right-wing members. So that's good news. So it sounds like they might avoid it one more time. You were telling me during the break. Sounds like they have a deal to avoid the latest shutdown, which would otherwise have been triggered when?
Friday.
Okay. Well, we usually find these things out a couple of days ahead of time. And all right, but a deal.
The problem is
yes.
It's coming awfully late in the day.
Oh. This deal announcement, you think? Or is that what you mean, it's coming late?
The problem is there is the 72-hour rule in the House for considering legislation.
Oh, well. To hell with that.
And
How
then,
about that?
the Senate being the Senate. So chances are they will need another stopgap bill. To just get them through the weekend. Or Johnson says, I know about the 72 hours, but Freedom Caucus is going to vote against it anyway. So, why don't I just piss them off more?
I guess.
And then we all get our 2-week recess for Easter started on time.
Okay. Well, that's
very
frequently of importance.
It's the usual.
Yeah. That's real leverage, right? So they could say, yes, I know there's this rule, 72 hours for you to consider all legislation, something, democracy, freedom, whatever. But vacation, that's the issue. Do you want it? Do you not want it? Freedom Caucus, of course, can say, I don't mind working because freedom, blah, blah, to which then you could say, Easter, why do you hate Jesus? Oh, all right, you're right. Okay, 72-hour rule can go out the window. They can waive it, or they can, as you say, well, I'll tell you what, we're going to have a CR that kicks this down the road some, but you need 72 hours to consider that CR. So in the meantime, how about this? A CR that kicks the kicking of the can down the road just a couple of days so that we can come back later and kick it again. Is that okay with everybody if it means you get to go home for Easter? And usually that's fine.
It's also worth pointing out that we are,
We don't know.
2 weeks away, less than 2 weeks away from the 6-month mark in funding the government for 2024.
Yeah, okay, right. Normally that's supposed to happen by October, and it is October of 2023. You're supposed to be ready for 2024, and technically that's the beginning of fiscal year 2024.
Starts. October 2023 is officially fiscal year 2024.
Right. So, I mean, nothing makes sense from the start. But we understand this cycle, but,
This is the latest ever.
Historical.
That appropriations have been done for the government.
A lot of history happening today. So that and Peter Navarro going to jail. That has nothing to do with the legislation. It's just a national holiday.
Don't know any of the details yet on what they agreed to, but what Johnson and team were pushing for, ironically, was to keep the FY 2023 levels for Department of Homeland Security going. They wanted the 5 appropriations bills in this tranche. Okay, we can vote on those, and then we'll do a continuing resolution through September for DHS at current levels, which was, kind of a big cut, actually, to Department of Homeland Security, to border control, to border security.
Yes. Right. All the, we need to do something. Emergency. Something has to happen. How about if we just continue whatever?
Yeah.
Okay. Sure. Yeah. Except that belies the emergency, but that's okay because it wasn't one. So from one perspective, all right, you're lying about there being an emergency. So, all right, we'll fund it at non-emergency levels. We're okay with that so long as we get to continue to claim that it is an emergency. Well, it's pretty clear that it isn't, right? No. We're going to lie. All right. I mean, if we all understand that this is a lie, go ahead.
This is a lie. Starving the Department of Homeland Security and border stuff. It was either trying to get Biden to take money away from other programs and put it all to the border, or just create enough of a problem with the border for them to continue to run on through November.
Yeah.
By not having this fund. I'm sorry. I just got trampled over by 2 cats.
Oh, okay. Well, that or she's rolling a piano across the floor. I don't know. That was interesting.
More fun to play on top of a person.
That sounded pretty good. Herd a buffalo. No, just 2 cats and a microphone. So, to be fair. Okay.
And I'm
hey,
talking,
cats.
so
sure.
That makes it even more fun.
Right.
All right, where were
that
we?
Wasn't I don't know. I
talking
lost
about
track
the
of
fact
everything.
that they want to keep things at the border as chaotic as they possibly can.
All right. I mean, not all right, but they're doing it. I understand this. Yes.
And because that's really all they've got to run on anymore.
Yeah. Well, that's central to everything, and they'll connect everything to it, whether it makes sense or not. At this point, it's everybody understands, everybody knows that's what's going to happen. I didn't even get a chance to open up the articles about it before I see they're going to make an issue. They're going to hang their hat on something. It's got to be immigration or the border somehow, right? Oh, yeah, there it is. Okay.
Yep.
So, nothing new.
So it's going to be again, do they push it to get out of there before Sunday, or they could, I suppose, vote. They could be in all weekend.
Okay.
But that would mean for Saturday and Sunday there isn't government funding for these 6 departments.
Yeah. Well, they've done that before, too. That's something that they deal with from time to time. In past government shutdowns, government has technically shut down over a weekend when it was mostly not operating anyway, but there are departments for which it causes a problem that the operations are 24/7, and they have to figure something out. But Congress frequently says, oh, I don't care, we'll fix that later. Easter isn't quite yet, so if Easter was this Sunday, you'd be pretty sure they would nail something down and get the hell out of here. But they have an extra week, so they might work the weekend in order to get it done.
They might work the weekend.
Okay.
They will likely
Calendar
work
is
the weekend.
extremely important. Yeah, right. Well, it's a big weekend to be home and to do things, whatever. I don't know. So that's what they'll do. And probably figure it out over the weekend so that they don't sacrifice next week if they don't have to. So it's all about the preservation of of contiguous days of recess. So,
I think really,
it's one of the biggest
particularly for the
drivers.
House, it's all about not spending time together in a room, even if it's as big as the House chamber.
Yeah, well, they don't like
with
being
people, to avoid people coming to blows.
Yeah, right. I know. At one point it was disease, but now it's just physical violence.
It's just that they hate each other so much.
Yeah, and right, and you don't even have to necessarily worry about it about separating the teams at the aisle, because over on the right they'll knock one another out at this point.
Yes.
They really are at odds. Last week we were able to bring the story that hardly anybody went to the Republican Party retreat. Nobody wanted to to hang out. These places where they say, well, if we're having problems among the staff or in a company or whatever, you bring people to a retreat. They get to know one another, and then those problems will go away. Well, I'm not even going to the retreat. All right.
This was a 2-day retreat, and they had to cancel day 2. And the only story, the 4 days of stories worth coming out of it about how Johnson was pleading with them to be nice to each other.
Yeah, not going to work.
This is supposed to be their big strategy session for the general election. How they, the new policies that they're going to make, policy proposals to run on. And
that's important. That's like a big function of what you are supposed to be elected to do. I mean, even though, one, what are you going to legislate? But I know you guys always ignore that. But at least, in your own interest, you get together and talk about how to get reelected, even if it's to do nothing again. And you won't even agree to that. And then, also, of course, they didn't want to go on the retreat. They didn't like where Johnson wanted the retreat to be. Let's have it a family-friendly retreat so that bring your families. It's going to be great. We'll all get together. No, if we're going to have a retreat, we want it to be somewhere nice and boozy, and maybe with strip joints or something.
No, there's a bunch of them saying, no, we can't be where there's alcohol because that will definitely end in violence.
That's true, too, yeah. So, I mean, he had all the excuses in the world to try to keep it family-friendly, but oddly, the family-friendly party wouldn't do it, wouldn't go for it. That is weird. Okay, so let's see. They probably will not have a major league shutdown at any point, even though there might be a technical interruption in funding for some departments for a few days while you're not meant to notice, but otherwise they'll use the calendar to get themselves out of here. Johnson can't get them to cooperate with one another, and you get the sense that they're just riding out this session, this Congress, and then, I guess we got to start.
Some of them are, giving up. Ken Buck.
Yeah.
Some of
right.
them
He's
are
not even waiting for the
making
end.
it worse. Matt Gaetz, who instead of going to the retreat, had a great deal of fun crowing about how he was going to Texas to campaign with a challenger to Texas Rep Gonzalez. I can't remember his first name.
Oh. Okay. Well.
So it's Gaetz being Gaetz, chaos agent. You know, really gleefully thumbing his nose at Johnson.
Right. Well, I guess thumbing his nose at everybody. Do we ever get a sense, does Gaetz have a preferred speaker candidate? Or does he just think, if we eliminate everybody, eventually I'll be speaker? Or just, I'm going to ruin everything for everybody?
I have absolutely no sense of what his motivation is.
Yeah. When it comes to the leadership thing, having been one of the primary movers behind the vacating the chair and getting rid of McCarthy, chiefly, I guess, to block investigation into his perverted activities.
That's probably mostly it. And he's an asshole.
Yeah, all right. Well, that's chiefly true, too. There's no problem with that.
I think the McCarthy business was mostly about the ethics investigation against him. And now it's just, I have no idea. Yeah.
Well, I don't know what's, I guess it's not worth spending too much time trying to ponder. All right, well, who would be speaker were the Republicans to retain the majority in the House? Do they just go with the inertia and say, well, I presume Johnson remains? I guess it actually matters, like, what the makeup of the House is when they come back, if they are in the majority. But
it's hard to imagine them coming back to a majority. They could.
It's difficult to believe. It's certainly hard to understand why people would return it to them, but that's not the question that's posed to voters. They're just, here's your local guy, yes or no.
Yeah.
But if we were a parliamentary system, I imagine this would be the end of their majority, but we're not, and we're gerrymandered.
At this rate, we could end up with Speaker Jeffries by the end of the year.
That would be an exciting and historic thing as well.
If the attrition keeps up. Ken Buck's parting shot basically was, don't worry about me, worry about the three coming after me.
Yeah. Wow. Well, this between this and just ordinary routine absenteeism in a body of 400, they have to watch and count every day. We're reminded, I don't know whether anybody is out there reminding anybody of the importance of votes on the journal, etc. Just the routine stuff at the beginning of the day to see how many people are here today and are the majority of them Republicans or not.
Because on any given day, it's not going to be. Already they're passing all of the big stuff on suspension with majority Democratic vote.
It is such a funny thing. I've been thinking lately about, we've all been thinking lately about the plight of constitutional law professors having to revamp their entire curriculum in teaching. This is how constitutional law works, just because of what the Supreme Court and others have been doing. But now thinking of government professors or, legislative process professors teaching about the use of the suspension of the rules procedure. Like this is typically, 10 years ago you would have, if you had a question about that and somebody said, what is this thing that they're doing, passing things under suspension of the rules? Oh, that's for non-controversial stuff that, flotsam and jetsam of the legislative process, naming post offices, etc. Things that nobody cares about, essentially, or objects to anyway. I don't want to say nobody cares about, but now it's like, well, but they're doing the whole, budget and all the appropriations bills, and every substantive piece of legislation is being done under suspension of the rules. And it might lead you to wonder, well, if the House of Representatives, which is so narrowly divided, can pass all of its legislation by a 2/3 majority, then, why can't how come the Senate, when it has an even lower threshold, can't do anything? With 60 votes, just 60% instead of 66%. The House is the more functional body of the two. What? No, it's the less. Oh. So.
Yeah.
I don't know. It's just very interesting.
So far, Johnson has been able to more or less keep to the Hastert rule. Stuff is passing with a bare majority of the Republicans.
I guess it is in compliance with the Hastert rule. How amazing.
That's still a thing. Believe it or not, the Hastert rule.
Yeah, they should get rid of that name.
Get rid of that name because I think, we might be the only ones old enough to remember what happened to Denny Hastert.
That's amazing, too. That's, yeah. Well, I don't know. I sometimes wonder about that. These things that we still make reference to that, you occasionally say, oh, yeah, there's a whole generation doesn't know what we're talking about. I think when my terrible joke about when Trump, his bloodbath comments, and then he was trying to spin them away. I was talking about specifically the auto industry, and I said he meant a bloodbath at HICFA, which was like a Gingrich joke from 1997 or whatever. I want Medicare to wither on the vine. No, I meant HICFA, the Healthcare Financing Agency. What? Okay. But that's only, 30 years since. I don't remember exactly when that happened. But these things, the cats are really having a ball back there.
The cats are yes.
Okay.
Yes. So much for my AirPods being unidirectional, whatever it is, masking out.
Give them to the cats.
And sound.
Well, when they're happy, we're happy, so it's okay. But yeah, interesting. All right. Well, I don't know. How did we get here? What did we depart from? The
Hastert rule.
Oh, yes, right.
Yeah, the dysfunctional house.
In general, okay. Yeah, but yeah, I guess they're still compliant with it in that it's a majority of the House Republicans approve of it, but it can't be done unless not only a majority, but the almost the entire Democratic caucus agrees. That's the upside down and backwards of the Hastert rule as we understood it at one point, which was really meant to be, well, we'll only pass this thing if we can pass it entirely with, or more or less entirely with Republicans. And it's now, well, technically we're in compliance with the Hastert rule, even though this is a Democratic bill.
Of the majority.
Wow. All right, I guess he never thought about that himself. They're not asking the framers of the Hastert rule what their intent was.
Hastert originalism.
Yeah, I don't understand. Okay, well, that's a bizarre development. I hadn't really thought about the fact that is in compliance with the Hastert rule, and that they would care to. All right, very interesting.
Maybe they don't care. It's quite possible that they don't care anymore, but here we are.
Okay. Well, yeah, all right. Anyway, that's unusual to say the least. Okay. Well, what else is on the radar if anything else beyond
Peter
that?
Navarro is going to jail.
Yes. Oh, right. That is exciting. Do you know what time he's supposed to report?
Oh, I wish I knew.
I can't find that out.
And watch that.
Yeah.
That would be fun.
I imagine there'll be a camera.
And I guess it's thanks to Chief Justice John Roberts, who said, yeah, no, we're not going to hear that appeal.
Yeah, I mean, that's pretty amazing that it even got to that point. But, you know, as one of the articles pointed out, this is a historic thing. No member of the of a presidential administration has, I think, ever been ever reported to prison on contempt charges in the modern era, certainly.
Not that I can think of.
So, yeah, I mean, it's not the kind of historical landmark you want to be responsible for establishing, but it is one. You can say he goes down in history. And yeah, I was trying to find out what time he was reporting, but nobody seems to have word on that. All I found out was that the prison is next to a zoo, which I don't know why I'm not certain why they told us that at all. In lieu of the time that he was supposed to report, maybe they just don't know. But I learned that much they got. There's next to a zoo, and the lions roar, and you can hear it inside the prison. Which I don't know what that's supposed to mean.
Okay,
but that seems to be true, and I guess they had to pay Stanley Brand to say something. So that's what he told us, and that he has a prison consultant. Navarro does.
Oh,
yeah.
Okay.
So I don't know.
Was this part of his plea? That he didn't want to have to listen to the Lions forum?
No, I'm not certain what that. No, I don't think it had anything to do with his plea. But I think it had to do. I mean, his prison consultant, obviously, we're told, was working with him to try to work with the judges to get him into the least prison-like facility. Although, I don't know. I mean, this is a very Roman prison facility, I guess. You hear the lions roaring. If there was some threat of the lions eating him at some point, that might be, that's good and punitive.
That'd be some fun Jeopardy, wouldn't it?
Yeah. But no, he's just going to have to do it. So he'll do 4 months starting sometime today. And I guess you could look up on the calendar when he gets out and start the countdown. But that's exciting news. Other items of interest or things upcoming, or are you just looking forward to their being on recess and not having to...
I'm mostly just looking forward to that.
Okay.
This has been the most ridiculous government funding cycle we have ever lived through.
Yeah.
We've seen some.
Yeah.
There is Ukraine.
Okay.
Still.
All right. Yes.
Which is getting pretty darn dire.
Yeah, it's kind of faded into the background as a constant worry, but yeah, it's been some time.
Lindsey Graham might be doing something useful to figure this out.
That too,
believe it
a
or not.
historic day.
Graham went to Kyiv over the weekend.
Oh.
Met with Zelensky, and he's got this idea that could, it's in early talks. People seem to be sort of receptive to it, but to say of the $60 billion, the $48 billion of it that goes to armaments and stuff, great, that's coming back to America because we're building the armaments here. That money is being spent at home. The remaining bit of it can be a loan, a waivable interest-free loan to Ukraine.
Oh, PPP for Ukraine.
Yes.
Okay.
And that seems to be something Republicans are considering allowing to happen. And Democrats who just want to get this money there are not saying that's ridiculous because it's Lindsey Graham.
Why. Sure. Well, that's... Again, opposite conclusion from me, but yeah, I can see why they would agree with it. And just in order to get aid there, it's kind of remarkable that you could get, we'll see whether he can deliver Republican votes, the requisite number of Republican votes. This is an easier thing to do in the Senate. But naturally, there will be some Republicans out there that say this is terrible for various reasons. One, they are pro-Russian, and two, they'll just lean on their, what about the debt deficit, what have you? We can't have this sort of the debt forgiveness. That's crazy, like student loans or something.
Well, the one thing that sort of could work for them is that Trump wants foreign aid to be loans. So they could look at it and say, this is a win for MAGA.
Okay.
Because this is a loan, even though it's interest free.
Yes. Holy moly.
That was a plant.
Okay. Was it a catnip plant by any chance? 'Cause holy cow, they tackled that. That sounded really good on radio. Like earthquake. Okay, everything's fine, everyone. I'm sorry.
On that note, I think I need to step away.
Yeah, I guess so.
I apologize for the circus.
I think this was the biggest hit. I think our, what our folks are like. Oh boy, cats! They should just put Mike the cats and let them play.
We should have to turn to video so we can see their antics.
Right. Oh yeah. Right. Absolutely. Well, pivot to video. We're going to do that and cat blockchain and probably AI next week. We're billionaires. That solved everything. Well, thank you, Joan, and good luck with that. And I hope not too much spilled out of that plant. And sounds like fun times.
Yeah, the pot's a goner, but.
Okay, well, we know what's ahead of you for the day. But on the upside, Peter Navarro going to prison. And who knows? Maybe you find a nice new pot for the plant and a couple other decorative touches for the house. Sounds like a good day. I appreciate you coming by under the circumstances. Good luck with them. And we'll talk to you presumably next week. And they'll be out on recess. And
we may have completely new fun stuff to talk about.
Okay. I hope so. Very good. And I hope you have a good week. And the cats do too. And we'll see you then. Thanks for coming by. All right, time for us to turn things over to Justice Putnam next on the show, or next on the channel.
NetrootsRadio.com.
NetrootsRadio.com.
You have been listening to Kagro in the morning with David Waldman.
You have, but that time is over. And it's now time to hand things over to Justice Putnam for the West Coast Cookbook and Speakeasy, where he will remind you that Trump's comments on Seb Gorka's show, of course, anti-Semitic garbage. Of course, there's more going on elsewhere. Voters in MAGA Shasta County, California are the subject of that report. Stay tuned to solve that mystery next.